Good afternoon. My name is Ramona Gwendella Womack. I live in Tacoma, Washington. I have a personal story of a nightmare in the criminal justice system in the federal court in Seattle, Washington. Our middle son, 35 years old, Maleek James, Brian James Womack, had to go through the criminal justice system, and we saw firsthand how the system works. There must be a reform. The judicial system must be reformed. Legislation must change the way the judicial system is ran by the prosecutors, the judges, the attorneys, and the clerks. We need more people to take a stand. Instead of allowing people to plea bargain, but to allow them to go through the court system and exercise their civil rights to go to trial. That is their constitutional rights. And every American should know their constitutional rights. With that being said, it doesn't matter if you know your rights, if you are indigenous, if you are African American, if you are another ethnicity, if you're just poor, you're going to prison. The system only works if you pay for it. You have to pay. The attorneys, everybody gets money when you go and pay an attorney. You don't even go to court. You just pay out. Or you plea bargain and you roll over on someone. And this is what happened to Maleek James. The two men who bought the drugs in, who were caught with the drugs on 12/15/09 and on 12/17/09, they plea bargained. They got less than 13 months. Maleek James is serving 9 years in prison for being a kingpin. And he wasn't even there when the drugs were seized by the police. So there's something wrong with this picture. When you turn yourself in 8 months later, after the drug bust, you go and turn yourself in, you take 2 polygraph tests and pass, and they detain you, and you're serving 9 years. So that's some of the story. But this has been a long nightmare for 3 years, because not only is Maleek James in prison, but his children are in prison. His family is in prison. His parents are imprisoned. And the government has got to know they're destroying families. So here's the thing. Does the Constitution apply to African American males in the United States? Our son's case number is CR09-427RSM. His appeals case number is 1130160. Maleek James, 35-year-old African-American male with a disability, decided to go to trial with the federal government. He was under the impression that it was the right, his civil rights, would guarantee him to the Constitution of the United States of America. James opted to take his case to trial because he was innocent. I have never been a drug dealer, he said, of any kind. More importantly, not a kingpin. And there was no DNA or evidence found to support these accusations made by the government. James said, I knew I had the articles of the Constitution to stand on, and that I would have due process of the law. Unquote. Well, it turned out Mr. James was wrong and realized that these articles of the Constitution did not apply to him at all. Because James did not wish to take a plea bargain, nor was he ever asked to plea bargain. Or to plea bargain, like many criminals do. Instead, Mr. James went to trial. The government was forced to arrange a mock trial called a kangaroo court for him, knowing he had a disability. He was not responsible. He had no money. He didn't have any boats and houses and cars and none of that. Therefore, James decided to go to court. This is where the story changes. When the government told Mr. James in July of 2010 to take a polygraph, if he passed the polygraph, they would not indict him. The head prosecutor said that. Under the representation of his attorney, Brian Hirschman, he complied with the government's demands. When James passed the first polygraph, the government told Mr. James they wanted different questions. Again, James complied, and again, there was no deceit found in his second federal polygraph. Richard Pergrin, one of Washington State's highly qualified and well-known polygraphers for more than 20 years, said, I failed more people than I have passed in my time and the federal and state polygrapher. And James had absolutely nothing to do with this conspiracy. Even prior to this indictment, James, the government knew he was going to be a material witness for a family member caught in the conspiracy. James was communicating with the family and the attorneys and was willing to testify on her behalf. However, on February 14th, 2011, James' trial started. It began with the voir dire, which is the choosing and the picking, talking to the jurors. And it started off with an all-white jury, not one of his peers. After the jury's selection, the United States prosecuting attorney had a Q&A with the jury. She insinuated to the jury that Mr. James's position in this conspiracy was that of a mob boss similar to John Gotti. James's counsel immediately objected to the questioning and to the comparing Mr. James with a mob boss, John Gotti, and Sammy the Bull, Gravano, Mr. Bentley, the defense attorney, objected to the questioning. The court overruled, and the prosecutor continued, stating that Mr. James was a kingpin. The images of the infamous mob boss John Gotti and the government's witness of Sammy the Bull, Gravano, continued to pour into the jurors' minds without any objections. In other words, the judge allowed the prosecutor to continue to taint the jury and to prejudice the jury by stating that Mr. James was likened to Sammy the Bull. Now, it's very important to know that there was guns with Sammy the Bull. There was 17 murders. There were gangs. And there were drugs. And none of that, Mr. James's case in the conspiracy, there were no guns. There were no murders. So this was out of context. However, the prosecutor continued. This was a sealing of their case against James. Even though the record did not support this, clearly this was a violation of James's Sixth Amendment right to a fair trial and an impartial jury. James was convicted and sentenced to 109 months, even though the guidelines range was 37 months. Judge Ricardo Martinez said in the sentencing, because James went to trial and wasted the government's time and money, he would not go with the range of 37 months. The government's two key witnesses were caught with the drugs and arrested, red-handed. Mr. James was nowhere around. These government snitches testified under oath that James and the woman did not know anything about the drugs. The judge sentenced Hussein and Pritam, who plea bargained, to 18 months for rolling over on Mr. James. James appealed his conviction and his sentence with the Ninth Circuit Court of Appeals. His court-appointed appellate attorney was granted an oral argument. He did the briefs, opening briefs, and the closing briefs. On August 31st, 2012, there was a hearing. There was significant court and prosecutorial errors in James's opening briefs. The United States versus James in the appeals court, 1130160. The conviction was confirmed by the circuit judges on 9/12/12. However, all three judges were baffled by the fact that John Gotti was compared to Mr. James. And in Mr. Gould's concordance, he stated that He did not understand that. Judge Gould, circuit judge concurring, stated in parentheses, I can't see no proper justification for introducing at voir dire the images of a notorious mob boss, John Gotti, and murderous mobster, Sammy, the Bull, Gravano. The jury panel, as a result of the prosecutor's questions, might have thought that James's alleged crimes involved organized crimes or violence or murder comparable to mob executions. Even those things that were not charged. The United States Attorney, Lester Borchesky, proceeded to paint the image of mob boss John Gotti as James after trial counsel objected. The court overruled, and the USA prosecutors continued the voir dire and proceeded on. According to James' trial transcript, the truth has been permanently sealed, even to Mr. James. For whatever reason, the circuit judges did not read James's entire briefs or James's entire transcripts, which clearly showed James's legal counsel, Mr. Alan Bentley, did object at trial and was overruled by the court. Page 41, opening briefs. Page 8. Appellate counsel for James prepared the opening briefs and final briefs for his appeal, also knew that the court overruled counsel's objection to the voir dire, but refused to correct the appeals court's argument on 8/31/12. All three judges stated, if the defense counsel objected to the voir dire, to the prosecuting attorneys questioning Mr. James's case, would have been overturned on 8/31/12. It would have been an error, a court error, one that would have overturned his conviction and his sentence. But that was not brought out. Even after the direct appeal, James asked his attorney what happened. The trial counsel did not object to this error, he stated, although it was in the opening briefs. He misrepresented James on his moment of oral arguments to state that this was a court error, and that the prosecutor deliberately tainted the jury. James's 14th Amendment rights to effective assistance of counsel and due process was also violated. James has been incarcerated for 3 years, seeking a way to get his entire case heard before a fair and unbiased judge. But James seems to believe that none exist for an African-American man today. He said he feels completely helpless and extremely embarrassed to be a black man in America. The bottom line, did James get a fair trial or a chance at this fair justice system? No. Was there judicial misconduct? Yes. Was there prosecutorial misconduct? Yes, there was. Mr. James' trial transcripts tells his entire story. But he was not able to get his transcripts. They were sealed. This was not a murder case. This was an open court. Yet, the case, his trial transcripts were sealed. I am his mother, and my husband and I are the biological parents of Maleek James, Brian James Womack. We paid, Mr. James went to court February 14th, 2011. The voir dire was the 14th. Court started on the 15th, 16th, 17th. The morning of the 18th, the judge gave the jury the instructions, and he stated to the jury, right before they went to deliberate, that Monday is a holiday. You folks have come a long way. If you hurry up with your deliberations, you will not have to come back on Monday. Monday was a holiday. So, with that being said, we went to lunch. Less than 2 hours, the verdict was ready to be read. Mr. James, after the tape of Kim was listened to or heard, which was some of the information was not supposed to be heard because Kim plea bargained. She plea bargained. So the judge stated at the beginning of the court, nothing was to be read about Miss Farah. Nothing could be brought into the court about any of the people who plea bargained. Yet, the tape was brought in of Miss Farah speaking to her own sister, and Mr. James happened to get on the phone. It was his wife. Nevertheless, they played that tape. The prosecutor broke all the rules. She played the tape that belonged to Miss Farah, which should have been sealed. And that sealed Mr. James's fate. Mr. James was convicted in less than 2 hours on all 4 counts. Bear in mind that the two men who plea bargained only received 2 counts. Mr. James received all 4 counts and 9 years in less than 2 hours from a jury of none of his peers. And so, can an African-American male get a fair trial at the justice system, in the justice system today? And I also believe that the government and the legal counsel violated Mr. James's rights as an American. Mr. James's rights as an American. And all we want to do is tell the story. You choose. Can an African-American male get a fair trial in America? If he's indigenous, if he's of color, another ethnicity, can you get a fair trial in America? And that's a very good question for the courts to look into. Are they biased? Do they take the matters into their own hands? Have they become so high and mighty that they become the god of the courts? The guardians of the courts are to oversee the courts, that justice prevails. Not greed, not trying to promote yourself or trying to get a high conviction rate. Justice is what it is. It is justice. Not justice for some, but justice for all. My son has suffered a nightmare. He has been through an egregious process. The judge and the prosecutor in this case took this matter into their own hands. And again, the proof is in the transcripts. And we need them to be unsealed because right after trial, on the 18th, on the 28th of February, 2011, a week and a half after the jury had found our son guilty, I called up to the clerk and ordered the transcript. We paid $970 to purchase bits and pieces of the transcript. Important parts, for instance, the judge's remarks that were egregious, which was a rush to judgment. It made the jury think that they could go back there and quickly look at this, deliberate this case, and then come out in less than 2 hours, and they did. The judge allowed the prosecutor to continue to say that Mr. James was a mob boss, which he was not. There was no murder in this case. The court decided to allow that, and that was the judge. So the prosecutor, she decided to taint the jury, to violate Mr. James's due process with the jury. And what's most important is what the most important thing is that what the appeals court stated, that this was a fine line, and why the prosecutor would tell the jurors that Mr. James was similar to a mobster. He couldn't figure it out. None of the three judges understood this. And each one asked the prosecutor, why did you use the mob John Gotti and Sammy the Bull? There were no murders. Did Mr. James have any murder? Was there any murders in his case? Was anyone murdered? No. Was there mobs? Were there gangs? Were there guns? One of the judges asked. It was a female judge. It really, really disturbed her. And the prosecutor said no. And so Judge Gould wrote a separate concurrence that he was really bothered by this, and that Mr. James has to do a 28 USC 22 file, a motion for a 28 USC 2255, which is habeas corpus, where he has a right to file that, which he has done. And Mr. James's spirits is very low. He's been away from his kids for 3 years. His wife, it destroys a family, it destroys his marriage, it destroys people. We want the judicial system to be reformed. We want judges to be accountable. We want lawyers to be accountable. We want prosecutors to be accountable. And we want the clerks to be accountable. This is the entire system needs to be revamped. And this case, if you look at it, is a great case. This case is unprecedented. When I sent my check for $970 to purchase the transcript from the clerk had to call me back 2 weeks later and tell me that the judge sealed the transcript only after I wanted to buy the transcript so that we could have a focal point to show that the two men who plea bargained said Mr. James didn't know anything about the drugs. The lady didn't know about the drugs. This is on the transcript. So there's so many things on the transcript that would free Mr. James. And that's why they were sealed. So finally, they did a redacted copy in November of 2012, almost a year and a half after, almost 2 years after Mr. James has been in prison. They released his transcripts to the Sheridan camp where he's residing in Oregon. And they were redacted. Things were taken out. We don't know who took them out. We just know that there was no reason for a man who's doing 9 years in prison not to have his own trial transcripts, not to have his own sentencing transcripts, and not to have all of his records, the criminal history that they used to get him indicted. And finally, I want to say that the papers, the press report that was read and sent to the newspapers, and this press release came from the government's office. This came from the government. Stated the Monday after my son's trial that Mr. James pled guilty and stated that he did do the drugs, that he set up the car, and that he admitted to being guilty of this crime. Why would Mr. James admit that he did this to the government and still turn around and go to trial? Or go to the appeals court, through the appeals court, immediately? Why would he do that? Why would he admit to this crime to the government? This is what Leska Borcheski said to the press, that Mr. James admitted to doing the crimes, admitted to getting the car. The car belonged to the man who was caught with the drugs at the Smuggler's Inn. Mr. Bowley, at trial, who is at the Smuggler's Inn, owns a Smuggler's Inn, was accused of forging Mr. James' name in his entry book, registry book. So there's a lot to be said about this. And until it's opened up, until the media, till the television or the newspapers get a hold of this story and look into it seriously, because if it's happened to Mr. James, it has happened to someone else. For you to go through the entire judicial system and still serve 9 years and you were never at the crime. You did not participate in the crime. There's no DNA. There's 2 polygraphs, which were $450 each, that you participated in. You paid $30,000 to attorneys who would not even help you. They just wanted more money. They wanted $50,000 to $100,000 to defend our son. So we just want to know, can an African American male, does the Constitution apply to the African American male? And no lie can live forever. please listen to our story, our nightmare, and tell us what you think. You can reach us at Ramona Womack, 52 at Comcast.net. Thank you very much for listening. And tell me what you think. Let's talk. Let's talk about this. This is a serious issue in America. Our criminal justice system is corrupt. Too many African American men are in prison. Too many people of color are filling up the prisons because they are indigenous and because they are of color. The Constitution is for all. The Constitution of the United States is applicable to all people. The right to life, liberty, and the pursuit of happiness. Thank you very much for listening. My name is Ramona Womack. You can email me